Well, you know, we're all about church-state separation. We take that very seriously, and so we thought we'd talk about the a big thing that happened in the news this week about church-state separation, and that is the Supreme Court decision on the pledge case. And we wanted to maybe bring up some issues of that, talk about the ruling a little bit. It also has sort of a Father's Day tie-in. Today's Father's Day, and you know, it was a man that brought the pledge, brought the suit against his school, his daughter's school.
Ultimate gift for his daughter.
Right, so. Right. So, and the whole issue of fatherhood and what that really means actually plays into this court decision, which is kind of interesting as well. So the pledge case is all about you know, the words "under God" in the pledge and whether those really belong there, whether children should be forced to say those in school and such. And
that was actually the main crux of the case.
That was the main crux of the case.
Not so much that "under God" was in the pledge. That was at contention. But the fact that in California, in the school district, they had a requirement for schools that they must have some kind of patriotic act. And that patriotic act would be mandatory recitation of the pledge at the beginning of the day. So
and then this "under God" phrase got put in there, right?
Exactly.
It became part of the issue, right? And for those that don't know, this word under, or this little phrase "under God" was inserted in the pledge much later after it was written. So it actually showed up in the 50s during
54, I want to say
54. That's right. And it was all about at that time. It was all about the communist scare and those pinko communists, and we got to distinguish ourselves from them. They don't worship God, or they've sort of, you know, suppressed religion there. Therefore, we got to promote it here. And at the time, that was very much part of the thinking that this distinguishes us from those guys. And there's this long, there's this very common contention that people have that oh, we can't say the pledge now, and they want to raise this as a persecution issue, that the children are not able to say the pledge with "under God," and that's just patently false. And I want to dispel that myth right now. The issue is about whether or not schools, as a representative of the government, can force people to make claims about religion one way or the other. It's all about whether or not the school is dictating something about the children, right? The children themselves can do whatever they want. They can add "under God" or not. So that's really what it's about.
And usually contention in that area is they're never forced to say it. Kids can always opt out of it.
Yes.
Now,
yes.
I have heard
we actually have we have to thank the Jehovah's Witnesses for that. So
but I've actually heard. I know we had a caller a couple months back when we were talking something about this related. I can't remember exactly how. In her school, it actually required a note from their parents to get out of it. So the kid on their own could not say, "I don't want to say the pledge," for whatever reason. They had to get a note from their parents to get out of it. And I just don't know if, I can't imagine that would be right. And also,
well, you know,
a child is able to opt out of it if they, you know, for religious reasons, for instance. But when they do something like that, they're basically placing themselves in front of the class to say, "Look, I'm different than everybody else."
Yeah.
And when you're in third grade, that's a bad thing to do.
In fact, I met a woman. We were on Lonnie Stern's radio show on KOP the other night, and we actually had a guest on with us who happened to be a Wiccan, but she was raised a Jehovah's Witness, and as a child, she had to opt out of the pledge, and she was talking to us after the show about how hard that was for her to do that, and all the difficulty and all the, you know, that her favorite teacher basically didn't like her after that, and all the peer pressure of her students, fellow students. It's not something, you know, it's coercion. It's that simple.
Kids are not legally required to say it, but they are definitely coerced into saying it.
Right.
So.
And of course, a lot of folks have said, well, this doesn't matter, right? It's just ceremonial deism. It's no big deal. Don't worry about it. But you know, when you have religious groups really fighting hard for it, and you have you know, the entire Congress making a big case to say this in front of the cameras, and I think there was a situation a while back where one of the congressmen led the pledge without the under God, which is the way he had learned it as a child, and there was a huge furor over that. And if it doesn't matter, then why would there be such a furor? That just doesn't make any sense.
And also the idea that just ceremonialism all of a sudden makes it okay. What if we still had things in place, as Amanda, a member of the group, had said, if it was just ceremonial racism?
Right, ceremonial racism.
It's just ceremonial or something.
So
like
this is a big slippery slope there, we think. And our group was actually involved in the case to challenge the pledge.
Yes.
We filed what's called an amicus brief, which is a friend of the court brief, and we were one of quite a few groups to do that. But that was our way of participating in this, and we made a lot of good arguments there. I believe that's on our website.
Yes, I believe, I'm almost positive it is. But yeah, Jeff D. and Amanda wrote documents that went into that, at least in part, and they made some excellent points in there.
Right, right. Another case they make is, well, if you say under God, it's generic, right? It applies to everybody, right? But if you think about Buddhists and atheists, they don't buy into this whole God thing at all, so they're excluded. Hindus have multiple gods, so they're excluded. We have the Wiccans, who might call it a goddess, instead of a god. We have the Muslims, who don't like the word God. They worship Allah, and God is, this proper noun thing is all messed up. Even the deists, the founding fathers, who are deists, wouldn't like this under God thing, because they don't believe that that God is sitting there watching and being a cheerleader or giving blessings in an active way. So this whole under God thing really excludes a lot of people. It really is about Christianity, in my opinion. Okay, so we had this Newdow guy. His daughter was forced to say the pledge. This happens all over the United States. It's not a unusual thing at all. And he challenged in California, I believe. Yes. And went through the Ninth Circuit Court there, and he got a favorable ruling for the pledge, and there was a big furor over it, right? And then it ended up going to the Supreme Court. It turns out he has a kind of unusual relationship with his daughter. He is a father of this daughter, but he is not married to the mother of the daughter, and was never married. Okay. He doesn't have complete custody of her, and this turned out to be a very, very important issue. Is the custody issue actually played into the Supreme Court decision, which we'll get to in a little bit. But I think one thing that needs to be said is pretty much anybody could make this challenge.
Yes.
Because it's a very common thing, pretty much, and anybody who has a child in a school district where this pledge is required. Yeah. So, and he's kind of an interesting guy, because he more or less single-handedly took on this pledge case. He went and got a law degree and filed all the papers and did all this, and he's never really argued cases in court. He's actually, his first job is
EMT, I think?
An EMT, well, an emergency room doctor.
Okay.
So he's a pretty interesting character, and we live in such a wonderful country for someone who really is passionate about defending the Constitution can actually do that without a huge amount of resources, with a little bit of help from others, it's just a great country to be able to do that. So, okay, so we had this go all the way to the Supreme Court, and they agreed to hear it because it's an important case. We have situations where they often take cases where the circuit courts come up to different conclusions, right? Because they need to sort of make sure that everybody's kind of in agreement with respect to the Constitution, and this is a big deal as far as the church-state separation. So they agreed to hear it, and then they decided that he didn't have standing, which is somewhat unusual, and that the lower courts didn't say that. And what this means is, in the way of standing, is it means that he wasn't injured by this situation, right? And this again hinged on his custody issue, that he didn't have full custody of the child, so in effect that he wasn't harmed by by her having to say the pledge.
Yeah.
Okay, and this is an important constitutional principle. You got to have standing, right?
Yeah.
You got to be affected by the law in order to challenge the law. So. So that's fine, but this raises a lot of very kind of scary issues in that a father, let's say we have a father and mother who aren't married of a child, and we have disagreements over religion or other things, or medical care or whatever, and now all of a sudden one of the parties is not able to bring suit in cases where it might actually be to the child's benefit for them to do that. Yeah. Right. So we have a lot of religious people that don't believe in having their children see doctors, right? Yeah. And so if we have a father who
which I think there was a case about that. I think it was actually a Canadian case.
Mm-hmm.
But
this comes up a lot with Christian Scientists and some of the other So it's a possibility that a child could be harmed by this, or that parents will have these huge custody fights in order to try to do what's best for the child, and I think overall the child's going to be harmed by this sort of thing. So,
but then again, the way that I was seeing this is, while I don't like that they essentially dodged it based on the standing, I can understand the idea that if they don't have standing, they shouldn't be allowed to go to court for it, because now while this is one of those gray area cases. And it's not like he was, a bad father and so they kicked him out or something like that. I can imagine similar situations arising where the father had been forced out of, let's say they were married, had a kid, and now the husband started, abusing the kid or something like that.
Right.
And then
was denied custody for that reason. Right.
Custody. Should the father then have standing to sue and say, to affect the life of the daughter or the son or whatever?
Right, right.
It can lead to some very scary situations, possibly. So I can kind of, sort of go on to it and understand where they're coming from with that.
Yeah.
I don't like how it turned out.
Yeah, so they kind of took a conservative stance in regard to that. It's kind of a delicate issue. It's not black and white. And given that problem was there, they, I think, more or less decided to not do it. And I was going to say that yes, they denied standing, but they also issued an opinion, which is kind of unusual too. Usually, when they deny standing, they just basically say, "Period, end of statement, go away." But 3 of the justices basically said, "This pledge thing is okay. We kind of like it." One of the justices, Scalia, recused himself, which basically meant he said, "I have a conflict of interest given that I've spoken out against it in the past.
Exactly.
I'm going to step down. I'm going to step away from this case," which is, I think, an honorable thing to do if you have a conflict of interest. And then the other justices didn't say anything, and so there's a lot of speculation about how they would have ruled. Yeah. So I've seen it spun lots of different ways.
Well, the only ones who actually said anything about this case were... I want to say it was Thomas. Scalia recused himself. I can't remember the justice, but they were all the ones on the far right. And so they're the ones who are basically going to say, regardless of any arguments that come up, we think it should stay. Yeah. And so they put forward arguments that this is purely historically based and all this kind of stuff.
So, but Clarence Thomas had a very odd case, very odd opinion in this. But go ahead.
But going on with it, though, I'm wondering what could happen, assuming, because they didn't make a ruling in any way, shape, or form. They just said, we don't want to hear it. If next year someone comes up with another case and they do accept it,
which is likely, now, it's likely will be challenged again.
All the wacko judges have just issued opinions.
Oh, are they all going to have to recuse themselves?
Are they all going to recuse themselves?
No, I don't think so.
In the next case, I hope so.
No, because they actually ruled this time rather than agitated.
Okay.
So I don't think so. I don't think so.
But still, it means that they're going in with an opinion before they've actually heard the facts of the case.
Well.
So.
Yeah. So well, they did hear the facts of the case in this case as well. I think Newdow did a pretty good job arguing the case.
Okay.
It was also unusual that he argued the case himself, by the way.
Yeah. Okay. So it'll be some gray area there, but.
Justice Thomas, Clarence Thomas, thinks he issued a ruling that basically says that states. He thinks that states can establish religions. Which is a very odd argument that the Establishment Clause doesn't mean that the entire government has to stay out of religious issues, which is pretty much what everybody thinks. But he thought that that states like Utah or Texas or whatever could say, well, our official religion is Mormonism or baptism.
Yeah, I don't know if that's the article that you're reading there, but I got an article forwarded to me from a friend this week, and I meant to get it on the list, about some of the rulings and opinions that Thomas has had in this and other cases.
As it turns out, there's something in today's paper about that very thing.
Very scary character.
He is.
He is a really scary man.
Right. And so he's argued that the Establishment Clause gives no individual rights or no individual protections to individuals. It's all about states as far as he's concerned.
Yeah.
So that's pretty odd, pretty interesting.
Yeah, he's a very scary character.
Yeah. So
I'll have to try and dig up that article and send that to the list and perhaps have it here next week.
As I said, in today's Statesman, there's an article just about him and his rulings.